A former soldier is facing at least 5 years in prison. His crime, it seems, is that he handed in a discarded shotgun to the police. 27-year-old Paul Clarke says he found the shorn-off shotgun and 2 cartridges in a bin liner in his garden. He took it all to his local police station, thinking he was doing a good deed, but he was arrested for possession of a firearm. In court, the prosecution said that possession of a firearm was a strict liability charge, so Mr. Clarke's honest intent was irrelevant. Lionel Blackman is the lawyer representing Paul Clarke. He joins me live. Is your client really facing 5 years?
Strictly speaking, that is the minimum sentence, unless the court finds exceptional circumstances. Now, you might think finding a firearm and handing it in to the police is an exceptional circumstance. However, there is no prescribed list of situations amounting to exceptional circumstances, so no one really knows.
Do you accept that as the law is framed, he was in possession of a firearm?
Yes, there was no defence in law. I should point out, Eddie, if I may, that this case has not yet concluded. The sentence has not been decided. The court may yet test Mr. Clarke's case that he found the firearm a day or so before handing it in. But I can only offer a comment on the basis, and one that was not contested by the prosecution during the jury trial, that Mr. Clarke did find the firearm and made arrangements to surrender it to the police. On that assumption, there must be grave concern that strict liability for the offence of possession of a firearm can lead to a prosecution and sentence.
Did you say there that he may have held the firearm for a day or two?
Yes, he said he found it, and the following morning he telephoned the police to arrange an appointment with a senior officer that was a day or so later.
Would there be any other circumstances that might account for the jury coming back after 20 minutes with the verdict it did? Is there anything else that we ought to know? Because on the face of it, people will look at this and think some people look at it and think he's being hard done by.
Well, the jury were true to the jury oath, which is to reach a verdict according to the evidence. And according to the evidence, he was guilty.
What are your options now?
Well, we do have to, as I say, wait for the final chapter of the case, which is the sentencing exercise, where the court has indicated it would wish for Mr. Clarke's case to be tested by his examination under oath.
Does he have any history of having firearms himself?
Well, it was disclosed to the court that he had on a previous occasion been found in possession of a cattle prod.
And that was the only thing?
Yes, which, of course, will be a relevant consideration to the final outcome, and may, of course, explain the precautions he took in the manner in which he chose to surrender this found firearm to the police station.
I guess the best advice, we spoke to Surrey Police, and they said that anyone who finds a sawn-off shotgun or handgun should treat it as suspicious and dial 999 immediately. It's not something that you sort of pick up and take home.
Well, yes, the law is not straightforward. There's little by way of guidance. In fact, the Surrey Police had a leaflet available at police stations indicating that one of the services at the counters of main police stations was for members of the public to report found or surrendered firearms. And indeed, apparently on Wiltshire Constabulary's website, there is just that advice.
Well, I'm sure our listeners will tell us a story or two in relation to this. Thank you very much for joining us, Lionel Blackman, who's representing Paul Clarke.